Hello and welcome. My name's Chris Moses. For the next 20 minutes or so, I'm going to be talking to you about managing staff grievances within town and parish councils, as well as code of conduct issues. Before I start, a little bit about who and what I am. I'm managing director of a small HR company based in the East Midlands, and we currently provide employment personnel advice to a number of county associations across England, as well as town and parish councils. So what's so fascinating about managing staff grievances within a town or parish council? Well, if you think about it, this is a small organisation. It's more akin to a small business with a workforce generally of less than 20 staff than to a council, such as a larger council of principal authority, where you've got the backup of HR departments, legal departments. In a town or parish council, you've got none of that. It's very much like a small business, but with one major difference. Small business operates for one purpose, and that is to make money. And all the managers, the directors, are aiming for that one outcome. In a parish and town council, the management team, the councillors, are all pulling in different directions. Well, occasionally, yes, it's great. They can all be aiming to achieve the same thing, and that's very constructive. But the very nature of the democratic process means that there is an inherent conflict, that some people are trying to achieve one thing while some are achieving others. That inherent conflict can create tensions, it can overspill, it can result in staff complaining about the way they've been treated and result in grievances. So who deals with the staff's grievance? Well, the legal position is that the full council is the management body. The full council is responsible for dealing with all employment matters, including staff complaints. But if you think about it on a practical level, for most councils, it would be utterly impractical for all members to be sitting in a grievance hearing, for them to squeeze themselves into a meeting room to deal with the staff complaints. Probably overpowering and rather unreasonable to conduct such a process as well. So the process in most councils, town or parish councils, is delegated to a committee who are of the right size to be able to deal with the problem. But it is important that that committee has clear and unambiguous terms of reference to enable it to do that. And the reason why I say this is because should an employee feel that their grievance hasn't been properly addressed, or that the people who are dealing with their grievance are the ones that they may be complaining about in the first place, they can complain of bullying, intimidation by those councillors by virtue of the fact that they weren't authorised to do the grievance process. There was no clear and unambiguous terms of reference that gave them the legitimacy to do the grievance hearing, the grievance investigation, etc. So this committee needs very clear terms of reference. I'll put an example on the screen there. I'm not saying this is prescriptive, something that you mustn't use, but for example, there in the middle, the committee will appoint a panel of 3 members when it is formed in May, and those are the people who will be called on should a grievance arise, and they will conduct the investigation and the grievance hearing. So it's very clear that the grievance process is the remit of this committee. The committee can make decisions on outcomes or necessarily refer to full council. It's up to you. There's no definites on this, but you do need to spell out how you will deal with it so that the people who manage this process can say they had the authority to do it. It is important that you have clear procedures and deal with these complaints effectively, because failure to do so, failure to follow ACAS guidelines can get a council into trouble. Failure to follow an ACAS guideline to deal with any grievance or disciplinary matter could result in a claim to the employment tribunal. In this case, it could be for constructive dismissal because the grievance hasn't been addressed in a manner that ACAS would describe. And in failing to follow that process, an employment judge, can award up to 25% on top of any compensation that's given to the employee because of the council's failure to deal with it as ACAS recommend. So it is important to deal with these processes, these complaints, these grievances properly. And the ACAS guidelines state that employees' grievances, they should raise them and the council should deal with them promptly and without unreasonable delay. However, if they don't, they can get into trouble. An employee can say, this council has simply failed to deal with my problem. It hasn't dealt with it promptly. The matter's dragged on for weeks, months. Still nothing's been done about it. I'm going to take my claim now because I've run out of patience. I'm going to take my claim to the employment tribunal. So the employee needs to resign, submit a claim, and that claim could be for constructive dismissal based on the council's poor conduct in dealing with its grievance process. I've mentioned also that if the councillors who were supposed to be dealing with it are not properly authorised by formal resolution and proper terms of reference, it can also result in claims for harassment and possibly even discrimination. So the council has a job to do. It needs to get on and tackle this, otherwise it could result in some fairly expensive claims, and a successful claim for constructive dismissal, for example, can result in an award of up to 12 months pay, plus a basic award, plus, as I've already mentioned, this 25% uplift. So for most employers, they get a staff complaint, a grievance, they put together a hearing, they deal with the complaints, they either find in favour of the employee or against, and hopefully the matter gets resolved. Unfortunately, for town or parish councils, the problem is a little bit more complicated. If the employee's complaint concerns the conduct of an elected member or members, then there is another tier of legislation that goes on top of the ACAS guidelines, and that is ensconced within the Localism Act of 2011. Section 6 says that the relevant authority, other than a parish council, so it's a principal authority, district, county, district council indeed, must have arrangements which allegations can be investigated and decisions made. Localism Act states that a relevant authority must include provision to deal with a complaint against a member or co-opted member of a parish council if that person's behaviour is subject to an allegation. So, whereas I was just saying as employers would deal with a grievance and decide the outcome, with a parish council, if that grievance concerns an elected member, then the problem cannot be dealt with by the council. It needs to go to the district council's monitoring officer. And that is a statutory entitlement for the councillor and an obligation for the staff. It needs to go, and an obligation, sorry, for the council. It needs to go to the monitoring officer. And this was investigated very clearly in the Supreme Court ruling, or in the case of Harvey and Ledbury Town Council. I no need to go into all the nitty-gritty of this particular claim. What is of most interest here is that in paragraph 103 of the ruling, Lord Justice Cockrell states clearly that to run a grievance procedure in tandem or as an alternative to a code of conduct complaint would be contrary to the intention of Parliament. What Cockrell is saying here is that a grievance procedure, and she doesn't state the degree of formality, whether that's a formal grievance or an informal grievance, cannot happen. You cannot do that if it's a code of conduct complaint. The matter has to go to the monitoring officer. And it's certainly, I've encountered examples where council has conducted a grievance process, it has investigated a grievance process, it has required a councillor to account for their conduct, which involves them preparing a defence, answering to their peer group, and in some cases, damage would be suffered to their reputation as a result of this complaint. Yes, I know these complaints are dealt with in a confidential manner, but in reality, word gets out, and the councillor who's being complained of can suffer a serious detriment. So, the council that has required the councillor to to respond to the complaint, to account for their conduct, is potentially in breach of Lord Justice Cockerell's ruling in the Ledbury Authority. And councillors have complained that those who have ignored this, who have conducted a grievance process of any nature, formal or informal, have breached that councillor's statutory rights under the Localism Act. And that can result in judicial reviews and all sorts of messy problems. So, the council has got very clear guidelines from the Supreme Court that don't touch it, you cannot investigate it, you've got to send it to the monitoring officer. Unfortunately, certainly in my experience, I get councillors who contact me and say, well, we've referred the problem to the monitoring officer, and they've come back and said it's not for them to deal with at this stage. It's an employment matter. We've got to run a grievance process. If we find against the councillor or in favour of the employee, then refer it to them. Now, let me be clear. My role here isn't to argue with monitoring officers. By no means. My advice would simply be to a council that if you get that response from a monitoring officer, simply ask them for some guidance. Ask them for some clarification on, does the advice that they've given fully comply with what Lord Justice Cockerell said in Harvey, particularly paragraph 103. And if you get written confirmation that, yeah, this is what you've got to do, this is how we do it, then the council has taken proper advice from its monitoring officer and will be following its procedures. What does a council do when an employee submits a complaint, submits a grievance? First of all, you've got to try and fulfill what ACAS have asked you to do. But we appear to be on the horns of a dilemma, because ACAS have said deal with it promptly, no unnecessary delay. On the other hand, the Localism Act, Ledbury, are saying don't deal with it, send it to the monitoring officer, which can take some time. It can result in a delay. It can result in several months waiting for a monitoring officer's decision. So a council, a parish or town council in this position, as I say, potentially on the horns of a dilemma, needs to try and protect itself, because it's not unknown, it's not uncommon for employees to run out of patience and say, I'm having no more to do with this. I'm resigning, I'm taking you to an employment tribunal, I'm making that claim for constructive dismissal. You've simply not dealt with it, and the problem continues. Under these circumstances, a council may find itself having to defend itself in front of an employment judge. And its role then is to try and demonstrate that it has acted within the spirit of ACAS and within the current legal framework that affects these matters. Now, what I would suggest is that once you get a complaint from an employee, you investigate it. The council or the relevant committee sets up a panel to sit down with that employee and go through the nature of their complaints. Now, if some of it is in-house, such as working conditions, pay, hours of work, that can be dealt with internally, and that can then be referred to a formal grievance hearing, and the council can resolve the matter, hopefully. If some of the complaints or all of the complaint is code of conduct, what Cockerell has suggested is that it's no longer this council's problem, it goes to the monitoring officer. If there are non-code of conduct issues, as I've already said, deal with it in-house. If it is a code of conduct, it goes to the monitoring officer, and the council should support the employee in that complaint, whether they make the complaint on behalf of the employee or they contact the monitoring officer and confirm with them what the complaint process is and how they can support their employee through it and provide evidence following their investigation. As I've said, council is on the horns of a dilemma here, because if it doesn't deal with a grievance, doesn't resolve the problem, and the matter's in front of a judge, the judge is going to want to ask, why haven't you done it? Why haven't you followed ACAS guidelines? So there's got to be a process of making this legal framework very clear to the judge, to the court, to ACAS, early conciliation, or whoever else, to make it clear that the council has tried its best. Now, in a recent case involving Leeds City Council, a claim was made against it by an employee of harassment. And the judge in this case threw the claim out because it looked at the council's policies, its procedures, its training, how it deals with grievance problems, how it deals with disciplinary matters, and said, what more can a council do? This council has taken all reasonable steps, and that's an important phrase. It's called a reasonable steps defence. The council has done everything within reasonable steps to prevent these problems happening. Now, what also happened in this case is that the employee who made the claim, the claimant, not just named their employee, but also named the named their employer, Leeds City Council, but also named the employee who had been subjecting them to harassment. And what the judge did is threw out the claim against the employer, Leeds City Council, but carried on to hear the claim against the employee who had been carrying out the harassment, and made an award against that harassing employee for their conduct. The council, as demonstrated by Leeds, can avoid liability, can avoid being found responsible for constructive and unfair dismissal if it can demonstrate that it's taken all reasonable steps. There's no fixed list to what those reasonable steps would be. And that's a good point for a town or parish council, because they don't have the money, they don't have the resources that Leeds City Council would have. They don't have the exhaustive HR departments, legal backup, and everything else. They've got very limited resources, but it doesn't mean that they cannot do the best they can to prevent problems such as this happening. Ensuring that staff and managers and councillors are trained and regularly reminded about policies and procedures. Now, a complaint that we often hear from councils, they come to us and say, we've got a problem as our employee has submitted a formal grievance against a councillor. We've tried to inform councillors, we've tried to give them all the training. Some are great, they'll turn up for these events, they will take it seriously, but some won't. And in this particular councillor case, the one that's being complained of, they refuse training. They just will not cooperate. Now, if that problem does end up in front of a judge, the council will still be able to say, we provided the training. We did the best we can. If this guy doesn't want to know, if this lady is not interested, what more can we do? We've taken all reasonable steps. Ensure that complaints and allegations of harassment, discrimination, bullying are investigated thoroughly and issues are addressed. If the council can take reasonable steps to resolve these matters, it can stand in front of a judge and defend itself. And what I'm talking about there are things like a transparent, simple, easy to use grievance and disciplinary procedure, stress management procedures, conflict management, communications protocol. Make sure that these policies and procedures are fully up to date, and that councillors and staff and managers are given regular training on how they should be used. And the regular training bit is crucial. In this particular case, Ali and Gellen, the employer attempted to rely on the reasonable steps case. It had all these policies and procedures in place, but the judge described them as stale. They hadn't been reviewed recently. They were out of date, according to the judge, because they should have been brought up to date and relevant training given. To be able to use the reasonable steps defence, a council needs to ensure that all of these policies are reviewed on an annual basis, and that staff and managers and councillors are retrained each year to ensure that they are up to date. They are kept fully aware. In Ali and Gellen's case, the employer didn't do that, and as a result, they were unable to defend themselves. So let me summarise, if I may. Grievances, they are a part of life. Staff become unhappy, and particularly in a town or parish council where you've got limited resources, you've got one clerk there to manage the whole affairs, and you've got councillors normally in constructive and professional disagreement with one another, but when it spills over, it can become unpleasant, and it results in these sort of complaints. The whole council is the body that is responsible for dealing with it, but it makes sense for most to delegate that responsibility to a committee. The committee needs to have clear terms of reference to protect its members so that they can't be accused of acting under their own steam, and that the employee feels that they were carrying out further bullying and harassment of them because they didn't have the proper authorization to do it. The committee also must ensure that it tries to work within the spirit of the ACAS guidelines to deal with a grievance promptly and without unreasonable delay. But it must also ensure that the councillors' statutory rights under the Localism Act are protected, and that the complaint, if it's a complaint about a councillor and their conduct, the council steps back and refers it to the monitoring officer and follows the monitoring officer's procedures and guidelines on how this matter should be dealt with. If the employee runs out of patience, if the matter becomes protracted and the employee decides that they need to leave, that they can't stay any longer, and they want to take the matter to an employment tribunal, the council has to provide a defence, and in doing so, that defence would rely on the fact that it has taken all reasonable steps to make sure that the problem didn't arise in the first place, that it has provided the right policies and procedures, that those policies and procedures are relevant to this organisation, that all members have access and know where they are and have been trained, and that training is up to date, as well as the documents. Okay, I hope that's been helpful. Thank you for watching. And all that remains for me to do now is to wish you a good day.